Good afternoon, and welcome. It is my pleasure to introduce our first speaker for the Yale Quinnipiac Dispute Resolution Workshop Series for 2016-2017. I am Charlie Pillsbury. I co-direct the Center on Dispute Resolution here at Quinnipiac Law School, and I coordinate the speaker series with my colleague Noah Messing at the Yale Law School. Unfortunately, Noah is in Australia today, so he had a good excuse for not being able to join us. Maybe he's looking into mediation around the world, as we'll be hearing about shortly. Let me introduce our very distinguished speaker, who reminded me when I invited him that he's been here once before. He spoke on September 10th, 2001. And when our then dean, Jen Brown, was organizing the speaker series. So he remembers, he still has the poster, I think, as a reminder of just where he was the day before that day. Professor Tom Stipanowich holds the William H. Webster Chair in Dispute Resolution and is the academic director of the Strauss Institute for Dispute Resolution at Pepperdine University School of Law. The Strauss Institute has been ranked #1 among academic dispute resolution programs in 11 of the last 12 years by U.S. News and World Report, and that has a lot to do with the talent of our speaker. Because he came to Pepperdine in 2006 after serving as the president and CEO of the International Institute for Conflict Prevention and Resolution, CPR, as those of us in the field know it, a Manhattan-based nonprofit think tank. He's also a leading scholar, speaker, and trainer on conflict resolution topics, as well as an experienced arbitrator and mediator. He is currently involved, apparently, in an arbitration case that has 42 lawyers.
Heaven.
He's perhaps regretting that he accepted the case at this point. He's also the author of more than 50 books and articles, and co-authored a leading treatise on arbitration that has been cited by the Supreme Court and many other courts. More importantly, in my opinion, he's also the co-author of Walter Kluwer's leading law school text and materials on conflict resolution, or dispute resolution, which I will be using next semester when I teach our introductory ADR course. In 2008, Professor Stipanowich received the D'Alembert Raven Award, the ABA Dispute Resolution Section's highest honor for contributions to the field of conflict resolution, and this year he was given CPR's, his former employer, the James F. Henry Award for Outstanding Achievement by Individuals for Distinguished and Sustained Contributions to the field of ADR. So I think it's actually, in that light, it's a pleasure really to introduce Professor Stipanowich in mid-career, because I think he has decades more to contribute to this field. So, Tom,
thank you so much, Charlie. Really appreciate it. Thank you. Well, Charlie, thank you so much for that kind introduction. You know, I did appear here, actually in the old building, on September 10th, 2001, and I remember aspects of that day very well. I've always loved coming to Quinnipiac, and I've been here a couple of other times. I'm delighted, of course, to see my good friend Jennifer Brown, and another friend I've known even longer, Harry Mazadurian, and some that I've gotten to know more recently, Bill Logue, Peter Benner, and Carolyn, of course. Just so nice to see so many friends, and we're delighted, Sky and I are both delighted to be back. We did live for a number of years in southwestern Connecticut, not far from here, when I was working at CPR, and we really do still consider Connecticut one of our homes. So it's great to be back. Today I'm going to talk about a whole range of topics, and what I'm going to do is throw a lot of stuff at the wall, and we'll see what sticks, what you'd like to talk about. I wrote an article after I had appeared to give a series of lectures as the New Zealand Law Foundation's International Visiting Scholar on Dispute Resolution. And I gave a series of speeches, and then over a period of months actually pulled it together into an article that you can read. It's easily available online, and touch more extensively on a number of these topics that I'm going to discuss today. I want to step back to the period of the early 1980s when I began law practice. And as fortune would have it, my period in professional practice is actually directly coterminous with what I call the quiet revolution in dispute resolution. I didn't come up with that title, but I've probably used it as much as anybody has over the years. I think it's a good way of describing what happened. I just want to relate very briefly a very telling, maybe a landmark experience in my own life. I was originally trained as an architect, and I began to work for a firm doing work nationally and internationally on complex construction and engineering projects. And what I discovered right away was the importance of out-of-court processes. Of course, back then, when they talked about we didn't use the term ADR, but if we had, we would have been referring to binding arbitration. And back then, one of my first big arbitrations occurred in the context of a very large construction project involving a hospital in the Chicago area. And we became involved fairly early on in the course of this project. My hair wasn't as white as this back then. I was the new boy who was helping with the represent the contractor in this dispute, a family firm. Well, the project continued over a period of time, was eventually concluded, but the litigation, the parallel litigation that had been going on the entire time, continued. And it actually ran for about another year or two after the building had actually been built. Now, to make it clear, my client had actually wanted to be released from the project because they thought it was going to kill their business. It was so serious a set of circumstances. Well, we won. We won the biggest victory I've ever had anything to do with or even seen. We received, for my client, all of the compensatory damages they sought, all of our attorney's fees, which were significant over all those years, and punitive damages in an amount equal to the compensatory damages. We had a celebratory dinner in Chicago. And I'll never forget that our client was very appreciative, but at the end of his thank you speech said, I hope you understand when we say thank you that we really are substantially regretful about this experience because this is not why we're in business. We're not in business to litigate. We're not in business to fight with lawyers to obtain money. We're in business because we like to build buildings, and we've not been able to do that. My 85-year-old father has spent much of the last 5 years in the company of, pardon the expression, lawyers. Isn't there some better way to resolve conflict? And those words resonate in my head. They continue to do so. I could give you other examples, but that's one of the better ones and one that had a big impact on my career. So when I became a law professor, I did begin to focus not on a variety of different approaches to managing conflict of all kinds. And that's really why I'm here with you today. And the themes that I began to investigate back in the mid-'80s when I became a law professor are still the ones that I reflect upon, I'll be talking about today, although we're in a different place. I think back to the dreams we had back then about what the quiet revolution might mean, because we were seeing that there were a whole variety of different developments that were occurring around the country and in some cases different parts of the world. We saw an opportunity to move beyond advocate-controlled processes to client-controlled processes, to move beyond adversarial processes and talk more about collaboration. Rather than focus on formalized processes, think about informal processes that might underpin better relationships. Instead of rights-based focus, looking at people's interests, the underlying interests that often drive disputes. And instead of long and costly, flexible, early, expeditious, and efficient. These were all appealing motives. Well, in my construction law practice, there were a variety of things that were happening, and they were happening very quickly. And by the early 90s, we were well beyond our starting point of litigation. Of course, arbitration, as I mentioned, had been a mainstay, a surrogate for litigation, if you will. And then, of course, growing use of mediation, which is going to be my primary focus today. In addition, there was what I would call the engineering solution to management of conflict on construction projects, dispute boards, where experts would be brought in to try to provide advisory guidance that might lead to settlement. I had experience as a standing mediator on construction projects, which meant that I'd literally be available to resolve conflict as it arose and even manage meetings on the job site. And finally, and this is a topic I'm going to touch on later on, I had experience in facilitating partnering processes, which continue to resonate with me today. I'll talk more about what that means. 3 decades later, where are we? Well, certainly litigation remains an important part of the landscape in commercial dispute resolution, although we know that the amount of trial has decreased significantly. Arbitration is really what you might call arbigation. It's become much more like litigation, and we're going to talk about the impact of lawyers and lawyering later. And mediation, of course, is a part of the lawyered landscape, which I've identified here. In the construction arena, we do have dispute boards, but you don't hear much about standing mediators and partnering. We'll come back to those topics later on. What about mediation? Mediation is the poster child of the quiet revolution. And here are some, just a couple of charts indicating responses from Fortune 1000 corporate counsel to a study we did, and we compared it to an earlier study in 1997. Our survey was in 2011. And what you can see is, looking at the gold columns, that, and you look over to the very left-hand side, you see that the most widely used approach to managing conflict with a third-party intervener is mediation. And in terms of the use of mediation had grown during this period between the surveys in virtually every category of dispute that businesses were involved in. Here's a quote from Fortune 1000 General Counsel, who said, our job as in-house counsel is cost control, not so much winning a case as getting a resolution, a business resolution that works and can be done quickly. And when you look at some of the comments we had to the Fortune 1000 survey, there were a lot of comparisons between, favorable comparisons between mediation and arbitration and other processes, talking about how the amount of control that it provided, the opportunity to either resolve the conflict or not as appropriate. These are all things that were attractive to corporate counsel. Here's another chart that I'll show very briefly that shows the frequency of use of arbitration and mediation. And you see that mediation is much more extensively used than arbitration. That should probably not be surprising for a variety of reasons. And there's also a very strong likelihood in various categories of disputes that mediation would continue to be used by the companies that were surveyed. I contrast that to some of the statistics we have on arbitration, which we won't talk about right now because it's not really our focus today. What are the factors that favor the global growth of mediation. The quiet revolution, at least as we've experienced it, was a U.S. phenomenon, but it quickly spread to a variety of other places, or resonated in other places. Well, now we have a whole variety of folks that have experience with mediation, in some cases extensive experience. We are seeing in international contracts the use of stepped dispute resolution clauses, where mediation, that is, using a third-party intervener to help the parties resolve their conflict through settlement, is part of the process. There is rapid global expansion of mediation on the supply side. As we'll see, there are lots of people who claim to be mediators, who have received training or some kind of certification. And that includes institutions that train them all over the world. And indeed, there are countries like Austria where there are extensive academic programs, even more than here in the United States, for academic or professional training of mediators. And today there's even a UN initiative to create an international convention on the enforcement of mediated settlements. I want to touch on three different areas in the next few minutes. First of all, question of how is mediation evolving? What are the international models that we're seeing? What are the areas, the similarities, but also areas of divergence that we're observing? Second, what are some of the international megatrends that are having an impact on mediation and mediation practice? And finally, is there some way of taking what we are learning about mediation, our experience as facilitators and users of mediation, to be upstream facilitators within relationships? So let's first take a very quick look at some of the evolution internationally of mediation. I always have to show this when I talk about our increasingly globalized society. You don't have to leave Los Angeles to immediately be immersed in multiple cultures, even at one time, which as represented by one of my favorite restaurants here. I nearly had an accident when I went past that sign for the first time. We did a survey. I'm going to show you data from 2 or 3 different surveys today. This is a survey we did of members of the International Academy of Mediators. And these are experienced individuals. We had a great response rate to this survey. I've not published most of the data yet, but I've touched on some of it that you'll see today. I'm happy to come back to this. There are a lot of sidelights I will point out as we go through. One of the first surprises to me was when we asked people about their ethnic background. You see that little sliver there, 1.6%. Those are people who did not describe themselves as Caucasian. So, and this is an international group of leading mediators. So that was the first surprise, just the homogeneity of that group, which is very troubling. I'll also tell you that only about 22% of the group were women that were responding to this survey, and that corresponds to the membership of this institution. And that's actually better than some groups of mediators. It's worse than others, depending on the area of specialty. In terms of professional background, I don't know how many of you would be surprised to hear that the vast majority of the people in this group are lawyers or have legal backgrounds. And when we looked at the amount of work they do or the percentage of time they spend focused on mediation, more than 70% said that more than 70% of their work time is devoted to mediation practice. So the notion of a full-time or most of the time professional is demonstrated in this data. Then we ask, well, how many cases have you actually participated in a mediator? Almost 3/4 of these surveyed mediators have logged in 1,000 cases or more, and some substantially above that, as you can see, into the thousands, just extraordinary. Now, we ask people, what do you do in mediation? And to me, this, of course, this is where it begins to get interesting. What do people do as mediators? And we ask many, many questions about mediation practice. That's why we've not yet produced a lot of the data, because there's so much of it. The one thing I want to emphasize is mediators tend to say we do whatever is appropriate or necessary. And we change our styles or our strategies to reflect the circumstances. So you see a number of the quotes that we had. My favorite one is this, which is something that my students always use in class. I ask them a question, and the answer, which they think is always appropriate, is, it depends. And they're right. Okay, now, one area of divergence that we observed was the use of joint sessions in mediation, where you have the parties, lawyers, everyone in a room together, and you're working together, you're talking about the problems together, versus what has come to be known as the caucus, where you take one party or parties off into a separate room, you have potentially confidential discussions, and then do the same thing with the other party or parties. And of course, what I didn't realize, I have to pause right here, I didn't really begin to focus on regional differences. We were just looking generally at trends. And I hope you notice when you look at this, you see we would give them a statement like, I began the mediation with all parties in caucus. And we were asking them to say, now how often is that true in your practice? Never, sometimes, about half the time, usually or always. Do you see there's significant divergence within the overall group? And we also use the statement, I keep parties in caucus throughout the entire mediation. Many said never or sometimes. Others said usually or always. So there's a big difference there in the way mediators approach their job with respect to caucus versus joint session. Well, I was giving a talk at a CPR meeting, and we had a panel. Turns out everyone on the panel was from California. And it was being led by a California judge, a former judge, who had very definite opinions about how you mediate. And of course, he relies heavily on caucus. And he said, does anyone anymore use joint sessions or something to that effect? Well, I could there was wrestling in the or restlessness in the audience, and I began to think, what's going on here? And people began popping up and getting angry and saying, who are you to tell us how to work? I use joint sessions all the time. What is this all caucus all the time mode? I've never heard of that. And finally someone got up and said, I think we need to replace this panel with another one that's representative of practice around this country. And we nearly had a fist fight among mediators. I thought that was really interesting. So I thought, I'm going to go back and look at the data and break it down. Now, some of these groups are smaller than others, but we did have a lot of California mediators in the group. And we had a lot of people from the US, but not in California. And then another group, maybe a third of the whole, that were from outside the US. Well, here's the way it breaks down. Now, what I'm showing here are weighted averages. So in other words, the higher the number, the more likely that they're going to begin the mediation with all parties in caucus. Now take a look at, can you see mediators in California? Their weighted average is a 2.12. They're most likely to begin the mediation with all parties in caucus. But then when you look just above that at mediators practicing outside the US, it's much lower, much less likelihood that you'll be in caucus, but instead you'll be in joint session. And for mediators in other parts of the US, but outside California, they're somewhere in between. Now we could break that down further, and I'm sure there would be other differences. But I just wanted to point out this one distinction. Now, going on, here's one. I keep parties in caucus throughout the mediation. The same pattern is observable. We're going to come back. I'll talk more about this, the California effect, in just a few minutes. But what's interesting is you do see a divergence, not just divergence within regions, but you see trends within, from region to region. How frequently do you do the following during cases you mediate? We ask people, whether they develop proposals that might lead to settlement. In one case, we said, we asked them, or gave them a statement, do you communicate proposals that one party makes to the other, but not make your own proposals? That was one. And then the other statement was, I develop and propose potential agreements myself. So we gave them those two options. And again, what you see is that you have a similar distinction. Mediators in California are least likely to simply communicate proposals. They're more likely to communicate their own proposals. And the mediators outside the U.S. are, again, on the other end, with mediators from other parts of the United States in the middle. So you'll have an opportunity later to go back and look more closely at these numbers. But that was intriguing to me. Now, these are some of the areas of divergence. There are many other areas where there's no divergence or relatively little. These were the places that we found. We're just talking before the program about the effect of culture. And this is one of the themes that I want to emphasize at various points in this program. When you talk about what mediators do, the way they see their role, you can't ignore the value system underlying the mediation in that particular region. I had the joy of taking students to a Chinese People's Conciliation Center, and which is actually set in a police department in a very crowded area of Beijing. And this is a place where they have mediators who are there to resolve neighborhood conflict. And these mediators basically bring people into their office, they interview them, they make a determination about how the dispute should be resolved, and they make recommendations that are followed 95% of the time. It's a very, very different kind of scenario. It's more, frankly, shades of Confucius and developments of 2,000 years ago. The role of wise elders, the commitment not to personal autonomy and to, making the most of my own interests, but really thinking about peace and solidarity within the community and harmony, Confucian values. And of course, these have been reinforced in the modern era by the Chinese government for various purposes. So you see a very different model of mediation going on there. And so I'm going to move on, but I just want to point out to you that there are these areas of divergence. And it's caused me really to go back and think about a variety of things. The influence of culture, the impact of attorneys, the impact of people having more and more experience with these processes. And that's not to say that it's going to evolve in the same way in every place. It's not. So we just have to be watching for how this is going to develop. So let's talk about the impact of the legal profession and what I would call gravitational pull. I think when we first began using mediation, and I was right in there. I helped found a community mediation center. We got people trained. My wife, Sky, was trained as a mediator, although she's not a lawyer, but actually did some important mediation in our community. And we were really trying to make it an engine of the entire community, bring people into the driver's seat, not just the parties. Well, of course, what's happened is with that center and many others, it really was taken over by members of the legal profession. and as most of the cases that are handled now are handled by lawyer mediators, and of course lawyers are representing the parties. Well, when we asked the International Academy of Mediators members, has your experience with lawyers changed through the course of your mediation practice? It probably doesn't surprise you that almost 70% said, well, yes, it has changed. So in what ways has it changed, and has it been good or bad? 82% say parties, lawyers, usually or always have substantial mediation experience. 77% viewed this as a generally positive development. At the same time, 90% said lawyers usually or always use mediation for resolving the dispute, which is what the intended purpose is. 78% said, of course, lawyers try to game the process, at least sometimes, by strategically withholding information. They use it as a means of continuing the litigation with no intent to settle, and even, in some cases, as a means of harming the other party. Now, I went back after our experience with the California and non-California mediators, and I looked closely at California mediators' comments, and I thought this was very interesting. Remember, we said that California mediators experience much higher percentage of their time in separate sessions, not joint sessions, but meeting separately with the parties. Why did this happen? Well, here's what one said. In California, counsel seemed to have taken over the mediation process. It's just not possible to have a pure mediation where the parties engage directly. On occasion, I've been specifically instructed counsel and the parties do not even need to see each other. In Los Angeles, the lawyers control the process and the legal personalities can be difficult. These same lawyers and others refuse joint sessions. At least 90% of the lawyers involved in the mediations I handle do not want to start with a joint session, and then explains reasons why they might not want joint session. This mediator is convinced that it's a positive development in many ways. But these are the kinds of things that our increasing experience with mediation indicates are part of the dynamism of the process, and the fact that we learn about mediation, but things don't stand still. They change, they evolve. And so I, as a scholar who works with practitioners and also practices, I'm concerned about these kinds of things. I see it as my job to say, we're drifting. How are we drifting? Why are we drifting? What's the impact of that, and what do we do about it? Now, speaking of drift, this is not to say this is purely unintentional process. It's actually, in many cases, very deliberate. We are doing what I call mixing modes increasingly. And by this I mean taking a process like mediation, or the skills of a mediator, and we're using them in different ways in adjudicative processes, whether it's a court litigation or it's a private arbitration where you have an arbitrator that will eventually be doing the adjudication and rendering a decision. How many mediators do we have in the audience? Let me just see your hands. Raise your hand, so many of you. How many of you have actually, as mediators, facilitated agreement not on, maybe you couldn't get an agreement on the actual substantive dispute, but you got the parties to agree on a process to resolve the dispute? How many of you have had that experience? Okay. For years, I have always at least explored that, where I had difficulty getting the parties to reach a substantive agreement. I would talk to them about process options. Usually that just kept them talking, and we would come back and resolve the underlying dispute. But the fact is, I've also had experiences where I've helped them flesh out arbitration procedures. And I could go into more detail, but I won't take the time right now. I think it's important to note that in recent years, there's been a very deliberate focus on these kinds of things, to say, the skills of a mediator may be used after a dispute has arisen to help the parties better determine how to tailor a process to resolve their conflict. It may come about as a result of a settlement, but maybe they need some kind of adjudication. Guided choice is the label that was developed by our friend Paul Lurie, who is actually the lawyer that was involved in one of my early cases, the first time we ever used mediation. So Paul is always thinking about the next thing, but Paul has suggested let's put a label on mediators laying the groundwork for conflict resolution, looking at process issues. Now, what about a mediator actually changing hats and becoming an arbitrator? Let me ask those of you who had raised your hands before. How many of you who have served as mediators, how many of you in the middle of a mediation or at some point in resolving a particular dispute, you changed hats and you became the arbitrator for the case? Any of you? Okay, one, and I have, and Bill is sort of iffy. You remind me of my students, Bill. You know, they never want to raise their hands all the way. Okay, all right. It was set up that way. Okay, so sometimes you might have what's known, sometimes called a med-arb process, designed that way. So the idea that you have someone try to mediate, and if it doesn't work out, you say at the end of the day, all right, we'll come back tomorrow and you'll be the arbitrator. Now, this is a controversial kind of approach. And if we have time, and maybe we will later on, to talk about these sorts of things, you know, usually U.S. lawyers are very aware of reasons you wouldn't do something like that. In other places, like China, like Germany, arbitrators mediate or conciliate all the time. And then the question becomes, what is actually going on in those processes? How do they deal with some of the concerns we have? One interesting thing is you will see that among our IAM mediators, most of them only do a little bit of arbitration, if any. But some do quite a bit of arbitration as a part of their practice. Also, a lot of mediators say, I don't want to arbitrate for a whole variety of reasons. Some say, I don't think the two processes go together, or I don't think I would be a good arbitrator. So there are a lot of reasons why you might not cross that border. And we have to recognize that right off the bat. Then, we, in the IAM group, we asked, well, how often do you actually switch hats? How often has it happened? And what we found, just to summarize very quickly what's here, is that one way or another, a substantial minority of the people we interviewed said, yes, I've done that at least sometimes. So it happens. And when we ask people, well, what was your experience? The top 3 bars are people with actual experience. Most of the people that have actual experience said it worked out okay. At least from my perspective, it was all right. However, when we ask people, well, why, if it wasn't satisfactory, why wasn't it? One of the issues is, if they know you're going to be the judge, the arbitrator, tomorrow, while you're being the mediator, will they actually be honest with you? Will they be forthcoming? Will they tell you confidences? Or will they simply try to manipulate you? Will they try to find out your opinions? Tomorrow, will they accept the fact that you're an impartial judge? Or are there some basic conflicts? Arbitration's about doing everything in a single room, in the light, transparent, an adversary process where you can confront evidence against you. Mediation thrives on confidentiality. It happens in the darkness, if you will, in the shadows. And so you have these issues about what happens if you're an arbitrator and you heard something the day before and you can't get it out of your head that might move you one way or the other. You might feel like, well, I don't know where this party's coming from. They made a confession about something that leads me to wonder how strong their case is. Then you have, or maybe they said something about the other party. Jennifer.
Are you open to questions?
Go ahead.
All right, so I'm having some questions in my own mind in trying to square what you just said here about the reticence to arbitrate with the earlier slides you had that suggested a very large percentage would actively inject their own views of the law or views of a good resolution in crafting a suggestion. And I think some people would say it's not such a sharp distinction between what those mediators are doing and what an arbitrator could do in a non-binding way.
You know, I'm glad you raised that, Jennifer. What you're saying is there's sort of a paradox here. Because we do have people within the context of their role as mediator being very directive. And they're not making binding determinations, but they are saying, here's what I think about your case based on what I've seen today. Bill.
In your survey, did it distinguish between a dual role in the same process versus somebody mediating a resolution, and as part of that agreement that arrives out of it, if there's an implementation issue, they come back to arbitrate it? Because there's 2 cases out of New Jersey and 2 cases out of Maine that have dealt with those combination of issues.
You know, that's a wonderful point. We did not actually break out that specific scenario, but that's a common thing where, let me just quickly deal with that. You have a mediator help the parties reach a settlement. They do reach a settlement. Then it says if there are any disputes arising under the settlement agreement, the person who was the mediator will arbitrate them. And interestingly, a number of these sorts of scenarios have ended up in court. It's happened multiple times in California as well. Maybe we should talk some more about that, because that's it. Let me just say that my project right now is to focus on this whole variety of mixed modes, including the scenario where mediators make predictions or determinations of some kind that are non-binding. MEDARB, the kind of guided choice approach, we're looking at all of them. And really, and I think some of these paradoxes, some of these dichotomies that we're dealing with will be brought out. And we'll also be looking at the kinds of scenario that Bill was talking about there as well. Maybe we can, yeah, go ahead.
About 1 o'clock, we're going to give the speaker another 7-8 minutes to finish up.
Yeah, I'll go ahead and then we can come back, because this is really, really important. You know, another area that I've been really concerned about is evolution of the rule of law. There have been issues raised here in this country about the heavy emphasis on out-of-court dispute resolution, the fact that so few cases go to trial, and wondering what's the impact on the evolution in our rule of law. I will tell you that whatever my concerns might be about what's going on here in the U.S., at least we do have an independent judiciary that is capable of and does resolve many disputes, and the law continues to evolve. Mediation cannot exist, to me, and be effective in a way we would think about effectiveness without having that independent judiciary as a backstop. And being able to rely on the rule of law at some level. There are countries where mediation is heavily emphasized, where there is not a tradition of independent courts. And one wonders, particularly I think about the People's Republic of China, where mediation is being very heavily emphasized right now. And there are many other things we could talk about in terms of how it's evolving. It's a little hard to tell you the truth. We don't have a lot of information out of China, although they say that mediation is growing and changing and developing by leaps and bounds. There's a lot more to deal with there. I briefly want to go through some other issues here, and then I want to turn it over for questions. And I don't know, again, we may want to talk about mixed modes, we may want to talk about other things. You know, some fascinating things are happening. One involves online dispute resolution and the use of infotech. Our use of electronic media is affecting everything, let's face it. It has changed our lives, and we have a whole variety of different things that are simultaneously coming into law practice and dispute resolution. Just to mention some of the more interesting kinds of things that I think we're going to see in the future. Online conflict modeling is something we already have. Extensive online mooting, that is, modeling a case and actually addressing it online, and gaming. Crowdsourcing. I think many of us who currently serve as mediators or arbitrators will be asked to give opinions online on a variety of different kinds of disputes, either for a single party or for both, either as an advisory matter or binding. You could have 10 people on this online jury or online panel. You could have 100 or 500 if the market would bear that, and ask them a series of questions and see what they say. We already have some online community courts. And of course, I think one of the great benefits of virtual conferencing and the evolution of technology is we can cover long distances. We can participate in conferences, but be tens of thousands of miles away. And finally, although Richard Susskind says we're not anywhere near this point yet, I think we're going to see avatars develop as dispute resolvers. For better or worse, this is going to be a possibility. Now, another area that's fascinating is brain science and data mining. We talk a lot these days at the Strauss Institute, I'm sure you do here, about the impact of human nature, the way the brain works, the impact of culture, which we've touched on a little bit, and then personalities. We deal with all of these issues. I teach negotiations, and we talk about a whole variety of different cognitive filters that affect the way we perceive things. This week we had a discussion on politics, and we're talking about confirmation bias, where people view every event, everything that happens, including what happened yesterday, as confirming their own view about how great their candidate is or how terrible the other candidate is. And these are things we're now actively talking about. We have a couple of former students. One has actually developed algorithms to predict what's going to happen in a particular negotiation just by pairing up numbers. And of course, Randy Kaiser has done studies on decision-making, lawyer decision-making, and what may or may not make decisions accurate predictors of where the case might settle. Another big area that we really have not come to grips with is regulation and credentialing. You have international organizations like the International Mediation Institute that are claiming the ability to try to provide some kind of international credentialing. You have other places, I mentioned in my article, Greece, where you have 1,000 certified mediators, although there are very few cases. A couple of years ago, when I had some of these Greek mediators in my office, they said they had 1,000 mediators and only 15 cases that had actually been mediated. So, these are issues that we're having to come to grips with. Finally, you heard me mention my early experience with what I call a partnering process. And I want to just basically touch on a larger role for mediation that we haven't yet embraced, or at least the skills of the mediator. When you think about relationships, one of the things we emphasize at my institute is the fact that, so often in the legal system we're talking about rights and responsibilities, legal rights and responsibilities. We're up above the line and trying to adjust those, make determinations about them in a contractual situation or some other kind of scenario. But we know as mediators that the life of the case, the life of the dispute, is really below the line. It's the drivers, the interests, the values, the concerns, the emotions that drive the case. And the great thing about mediation is it's not simply dealing with that part above the line. It also has the ability to come to grips with everything else. My colleague Dwight Golan, who many of you know, is and co-author, did a wonderful study a few years ago. He actually wanted to know about the use of mediation in cases involving relationships of some kind. Now, some of these were people who had been married or parents. They might be commercial relationships, some other kind of connection between the parties. And he developed these were admittedly rough, but from a variety of sources he tried to develop some sense of how often you actually get a repaired relationship, or some kind of integrative term, not just giving somebody money, but actually something else, like someone performing something or maybe making an apology. And what he found out was that almost half the time you could have one or the other of those things. Now, what were the factors that favored repaired relationships? One is how quickly after some kind of rift does a mediator get involved? That should not be surprising. How important is the relationship? Do they want the relationship? Are they done with it? What about that? How unique is it? What's the quality of the options and the sunk costs? Also, what are the attitudes of the participants? And who are you talking to and when? Can you establish relationships with the business people or the people in the relationship and find out what they want? So often, mediation occurs way down the line in a lawyered scenario, and these opportunities are diminished greatly. So what if we move the skills of the mediator upstream? Well, we know that there are various kinds of real-time intervention today, and I'm sure that people in the room have experience with different kinds. I simply want to touch on one very interesting approach, which I used a good deal in the late 80s and early 90s, working with one particular company that had a variety of different kinds of areas that they worked in. Partnering was a concept that was borrowed from manufacturing and distribution sectors and pioneered by the Army Corps of Engineers. The idea was to bring people together at the beginning of a relationship, typically a construction project of some kind. But shortly after contract signing, you would have all the team members come into a room like we are today, but talk about the project. Talk about it in terms of what can we do to enhance the trust and cooperation between the parties? What are the concerns going forward? How might we understand each other's expectations and objectives, and how can we resolve disputes as they arise on the job? Some statistics were developed back in the 1990s on partnering, and at the time we thought, this is the wave of the future. But you know what? It never went anywhere, and there are a variety of reasons for that. Let me suggest to you that we did some work at CPR, trying to do some lateral thinking and apply these approaches in relationships between companies and IT providers, because there are a lot of comparisons between, say, a construction project and a long-term relationship between an IT provider and a business or an entity. And what we found was that partnering can have great value in enhancing relationships, improving communications. What is it you're worried about? What am I worried about? When are we going to have to deal with it, and how are we going to deal with it? Learning about others' goals and priorities and ways of dealing with problems, managing issues and conflict in a constructive way, and exploring outcomes that address business objectives. And where disputes arise, coming to grips with them at the earliest possible time. Now, we don't have to call it partnering. There may be many other ways of looking at this, but I think back to my time as a standing mediator, and I say to myself, are there mechanisms that we could create that are closer to the ground, that may function in real time, to allow mediators to get involved before the parties lawyer up so that they can maintain and reinforce bonds of solidarity and trust within a relationship? Well, that's the end, and I think there are a number of places where this may be applied. But now I want to open it up to all of you. I don't know what that I have raised might be of particular interest, but I'm certainly happy to discuss this with you. So thank you for listening.
name and who
Oh,
you-
sorry, I'm Mandy Smallhorn, I'm a 2L here at Quinnipiac. The pie chart with the slice of the, the predominantly white pool of mediation. I'm sure there's a lot of reasons behind that, but it is kind of surprising that globally that is mirrored. And can you, again, I don't know if this was the focus of your research, but can you speak to why you think that's the case and how?
I have to say that that really was extremely troubling. I expected the gender disparity, and that I can explain to some extent, at least from in the U.S., since it is largely a group of lawyers. At the time I graduated from law school, I didn't realize this till I went back and looked, but in 1980, only a very small percentage, maybe somewhere around 10 or 12% of the practicing lawyers in the United States, licensed members of the bar, were women. I had no idea, even at the time, it was that small. When you think about who the typical mediator is, it's often a member of the bar, usually not someone who's early in practice, but they have moved through law practice and have then come out and are, particularly in this group, where you have, they're what we'll call term commercial mediators. And they do a variety of different kinds of things. But often that's a result of being part of a network of lawyers, and other lawyers pick them. Now, I'm not defending that. I'm just saying that's the approach. So I think that explains the gender disparities, and maybe to some extent the disparities relating to race and ethnicity. Still, it blew me away. It really surprised me. And we did a study of arbitrators, and we didn't ask the question about ethnicity. I wish we had, but knowing the group, the result would probably be virtually the same. It really is surprising, and in certain areas in particular, I can tell you it should make a big difference. I remember I had one case involving a minority subcontractor, and it was a construction case, and it was one of the easiest mediations that I ever conducted. It just went exactly the way you want it to. I caucused with the parties, and of course we brought them back together. We thought we had a resolution. The lawyers were very pleased and said, hey, this is going great. We get to the very end of the afternoon, and the principal on the one side, this minority subcontractor, said, I'm sorry, I can't participate in this resolution. Words to that effect. We were all shocked. We didn't know why. And it wasn't until a day or two later when I spoke to this gentleman's lawyer, who was Caucasian. He said, my client just felt like, even though things seemed to be going well in terms of numbers and the resolution, he couldn't buy into the process. He didn't see himself in the process because he was the only minority in the process. That really taught me a lesson. So something I just blew completely over me, and all of us. So, this does make a difference, and it could be a business matter, it could be employment, certainly, and other kinds of situations. This identity and relatability does matter. It goes beyond simple establishment of rapport. Yes?
This sort of ties into that, actually. So the online conflict resolution, you can't really relate to the client in that way, or you can't, I guess it might help in the sense that you couldn't see race through the screen or anything like that, but have you recognized any sort of issue in terms of not being able to relate online in mediations?
I've had no experience with purely online processes in mediation. I know people who have, who did some of the work with eBay, Square Trade, and I've not collected any specific data. It would not surprise me. That's very different.
That's right. Back to Manny's question. The ABA section on dispute resolution has a very active women's section, and they've done a survey of mediators and arbitrators by subject matter, and that's available through the APA opinion. It shows some of, not quite as extreme as what we've seen here.
I should emphasize, by the way, that this is one group. They do have a wide variety of kinds of mediation that they do, but these are fairly successful mediators in the larger realm. I think if you look at mediators by specialty, family mediators, et cetera, you'd find different statistics. So I don't want to suggest that these numbers are all-purpose numbers. You really, and there, by the way, Carol, who is it? Izumi, I think, trying to remember who it is, that has actually collected some of the numbers on this, and you might look up one of her articles and see if you can find it. I saw her present something not long ago. Yeah, Harry?
Tom, you've identified as promised a mega roadmap for what we have to do, what's ahead of us, including quantification, identification of what works and what doesn't, best practices and new models and regulation. But in the early days of ADR, the mantra was let 1,000 flowers bloom.
Yes.
And I'm wondering what sort of tension there is between all of this evaluation we're doing now and allowing those flowers to bloom. Are we going to have a dampening effect once we decide that, gee, the joint caucus is the bad way to go, or this is the best model, for those new flowers to wither and not to be planted?
I'm with you on that. I don't like regulation, or at least I resist that in the sense that I think that should be, there are appropriate uses for regulation, but I'm an educator, and what I'm hoping to do is just make sure people are aware and deliberate about what they do. They may make different choices. For example, in our mixed mode group, ultimately what we hope to do is, first of all, make people aware of the different kinds of expectations that exist in different places, so that if you're engaged in an international mediation with a Chinese party, no one is surprised about what might happen. Just to understand, well, here's different backgrounds, different cultural backgrounds and models. We might also provide some guidance to say, now here are some things to think about depending on what your goals are. But your goals may vary greatly depending on your background and the circumstances. So I think we have to, I prefer the light touch. I prefer raising awareness, but not telling people what they have to do and limiting their options. One of the things we're seeing in places like Brazil is saying, making some strictures on mediation before they even have much experience with it. And they're doing it based on limited information. And I mentioned that in the article as an area of concern. That's not what I think we should be doing. I think regulation is fine in limited areas, but I really believe we need to let things develop. At least that's my bias. I love the old days when we were experimenting, and to me, that's still where my heart is.
Yeah.
With respect to the aspirational partnering upstream, furthest upstream, what's the role of lawyers? And is the involvement of lawyers potentially an impediment to an evolution to that kind of model when you're looking at relationships and business objectives?
That's an excellent question. I think I will tell you that I did a partnering in conjunction with a 100-site teleconference involving Tom Peters and Stephen Covey, and I can't remember who else. But we did the partnering session at Covey's headquarters, and I believe it was up at Sundance years ago. And I remember we had lawyers in the room because they had just finished the negotiations. And actually, as a result of the partnering, they did go back and talk some more. But I remember one of the lawyers came up to me and said, because normally lawyers are not involved in the other experiences I'd had. And this lawyer said, gee, you know, this was amazing, because he said, I've negotiated contracts like this. But he said, this is one of the few times I've ever had the opportunity with my client and the others to put flesh on the bones of what we negotiated, to really understand what it was all about. What are the dynamics? What are the concerns people bring to the table? What are the real worries? And how can we come to grips with those? He was saying it was good, it was really good for him, and he thought therefore good for his client to be there. Now, that's one, that's one person's experience. My thought would be that lawyers might or might not be involved, and that certainly that could change the dynamic dramatically. Bill?
Are you seeing any stratification, going back to Courtney's question about online dispute resolution? I think when we think about that, we tend to think about the high-touch model that many of us are engaged in. I don't know what the recent statistics are, but when Colin went out to eBay, Colin Rule, they were doing 10,000 disputes a day on eBay that were automated resolution, and then you get into some guided discussions. The role of big data coming forward, consumer disputes, artificial intelligence probably solving many disputes within the next decade. So that kind of, those smaller disputes where there is perhaps a greater predictability of patterns of both bargaining and outcomes, and the need for lower costs versus the larger disputes, which I suspect were the ones you were surveying on, and any kind of patterns that you're seeing in terms of the nature or type of disputes, in terms of complexity and level of involvement.
You're speaking again about online
well, I think
processes?
I think any form of dispute resolution. Is it going to be just the big money cases that can no longer get tried, that go to these kind of highly skilled, more expensive mediators, and everybody else is going to be left to an online system? Or
it would not surprise me if at least for many, an attractive option is electronic, involves application of some kinds of algorithms to a scenario. I mean, it's just, when you think about the economies of scale. Does that make me happy? No, I'm just trying to anticipate what is likely to happen. I think one of the big challenges has been, what do we do with this vast array of consumer disputes? And it's gotten wrapped up in the politics of binding arbitration, and has really created no end of debate. And I think that as time goes forward, I've talked to Gene Sternlight and some other colleagues about this, and I think at least part of the solution may be provided by some of these new opportunities that are created by electronic systems. That doesn't mean it's going to be perfect, or that we're not going to have problems, or there won't be mistrust of systems. There'll be new opportunities for gaming or for manipulating. But I think we have to think about it in terms of, is there a way of enhancing access to some kind of justice that maybe did not exist before? So, Bill, that's probably not a very satisfactory answer. I'm wondering too, and our friend Colin Rule would probably be in the best position. I don't know, he probably has or will be coming here. He's someone who is always worth talking to. But of course, so far, he would be the first to say the vast majority of applications of his technology is in large-scale, small cases. I mean, where you have a wide, a whole bunch of cases, and they're not very big. Yeah.
Carrie, and then
I wanted to pick up on what Peter was saying and what you were saying on the partnering. I'm absolutely not an expert in this, but I have heard about a movement called conscious contracting. I don't know if you've heard that term. And I think there's a workshop going on, or just finished, on training lawyers to bring the skills forward and to think about helping their clients form contracts with a very different methodology and purpose. You know, they start with, let's have our own mission statement of what we're trying to do here, and let's try and articulate what's going to make this relationship work, instead of just identifying what are we going to do when it doesn't work.
Yes.
And I think there's a new text coming out, the idea of teaching contracts and the art of deal making differently. I can find some names, I don't have my phone here, my trivia machine to look it up, but I went to a workshop at the ABA dispute resolution this past April and listened to them talking about it because I didn't know what they were talking about. And I think it would, it might really pick up exactly what you were.
Yes, yes, very interesting. No, I'd love to know about that. Thanks, Carolyn. And then
Jen.
Jennifer. Yeah.
Bill.
Oh, sorry.
Are there ways that you can think of, or ways that are in process, to have the dialogue and deliberation that you're calling for not be dominated by either the providers of ADR or the lawyers, but instead by the clients, the people whose interests are, who are really the party to these cases? If I remember correctly, CPR was founded by companies.
That's right.
But I also have the impression that it's very unusual to have a mediation organization that integrates clients.
Well, you know, it's interesting you mentioned CPR, because when I was president at CPR, I recognized that the participation and support of the legal department was absolutely critical. I did not think it was sufficient. And I badly wanted to move the emphasis beyond the legal department. And where, Harry, I don't know if you were ever involved with the employment committee. I think there we probably were able to some extent, move beyond the legal department and bring in other principals, decision makers from within the company. But we never got really into the C-suite. And I always felt that was a personal failure of mine. It's great to have the lawyers involved, and it's essential, but it's not sufficient. So even CPR had its limitations in that area. It's very hard to jump that divide and actually get the people engaged. I personally do believe there are models for making users more aware, more deliberate about what they do, but ultimately it's their call. And over and over again, looking at some of the other things I've been involved with, we've tried to encourage users to be more thoughtful and make choices and be active and deliberate about that. But they've got a lot of other priorities. Dispute resolution is very low. Pre-contract or at contracting time, that's, and the emphasis is always on let's get married, let's get the job going, we're excited about this, let's not dampen our enthusiasm with talk about prenups and all the bad stuff. It's really, there are a lot of barriers to getting people engaged. I think that's one of the reasons, that and failure of execution is one of the reasons why partnering never took off. I think a lot of it was very superficial. My own experience is if you really get down to the hard discussions, it can be very beneficial. But you have to find people that see a value proposition. And a lot of people just don't. They say, this dispute resolution stuff, isn't that what my lawyers are for? They tell me what I need to put in my contract, and then if a dispute arises, we'll get the lawyers involved. So it's very, very hard to bridge that divide in my experience, at least in the commercial realm.
Jen?
So this is a comment, and I think it may be a little provocative and a little pessimistic, so I hope you'll explain to me why I'm wrong. I'm wondering whether instead of talking about the evolution of mediation, we might want to be talking about a quiet counter-revolution in mediation that picks up on that slide early in this presentation that, sort of had the two sides and, going from advocate controlled to party controlled.
Yes.
And, if we think about advocate controlled, formalized, adversarial, rights-based, and zero sum, based on conversations I've been having the last 12 months, I really wonder whether the move to more court-connected mediation, and even on the private side, more mediation being done by former judges, is moving us back toward that, those kinds of descriptors could apply to the mediations that are going on. And, maybe that's only in certain subject areas, less on the corporate and commercial side, maybe more on the personal injury side. But I'd love to get your views on that.
Yeah,
I think somebody should
it's-
be addressing that.
Well, it's easy to be very cynical about it. I think that does come through, not by accident in what I'm presenting. For one thing, when we started out, we really didn't stop and think about the importance, the huge impact of the way lawyers work, the way lawyers approach the things they do, and the impact of traditional lawyering models on whatever it is we're doing. It's huge. The gravitational pull of the legal profession has been immense. And meanwhile, a lot of, I've told a number of people how frustrated I am because I feel like my own scholarship has been very retrograde. The dreams that I dream right now are much more incremental and much less exciting to me than the stuff I was talking about 20 years ago or more. And part of it is simply reflection of what's developed. It's not simply that I'm more sophisticated, although maybe I am, seen more, but it's just watching things evolve. And I think we really have scaled back. In fact, when I talk about the dream we had in the 1980s, actually wrote a piece for the construction lawyer they were doing a kind of a futurizing issue. And I said, we just didn't do it. We didn't do what we thought we were going to do. And, everything it's been heavily influenced by the legal profession. We haven't embraced the more exciting alternatives and the ones that could be most transformative. But at the same time, I said, we have some things coming that could have an impact. Electronic platforms, for example, for the entire project that could be a locus for managing conflict. And there are contract models that are very exciting that might provide mutual incentives for working together. But we're not there yet. Bill?
I guess a comment, maybe push it back to your dinner table. I haven't read it yet, but John Landy has been writing about how we teach negotiation theory and everybody loves it, and when they go out and negotiate, it all falls apart and they revert to old habits. So I don't know if there's any lessons from Duhigg there on habits and how we find the right intervention. But if you have evidence that negotiation theory as it's developed over the last few decades works, but people don't implement it, is there a way of aligning incentives into the process so that people will use that theory in application? And with that success, does that then change the habit over time so that they then do it? Because I see this in mediation all the time. People are negotiating before the mediation in a very position-based process, and they come in and they do not want to shift, the lawyers do not want to shift to an interest-based process. So I don't know if there's a way of aligning incentives about the way people conduct themselves.
Well, as I was saying, there are examples of contracts, and again, construction is the area I'm most familiar with, where you do have an alignment of the interests of the contractor, the owner, et cetera. The entire team is really all theoretically on the same side of the table and they're dealing with the same problems. That would be the most direct way of really trying to engineer the underlying interests into a way that will hopefully allow the that kind of less positional and more integrative bargaining. You know, the way I think about it, I have to say that in my experience as a mediator, I usually, the dominant model was positional, but that integrative insights were very important to me and often were keys to overcoming impasse. Although ultimately we'd probably end up coming back to positional bargaining, back and forth until we got it resolved. So, you know, that's my own experience with it, and it'll be interesting to see what the impact is. Maybe this is John's thesis that there's a further impact of people that have been trained in negotiation, but maybe not the one we thought it would be. So, again, I realize that my own expectations are often defeated because I'm not a good predictor, and one thing I am doing is picking up more information and saying, well, you know, here's something to watch. Where we will end up, where we'll come out of the tunnel, I don't know.
So we're at the 1:30 witching hour, which means this is anybody who needs to leave is free to leave. I'm sure Tom and Sky will be here for another 10-15 minutes to answer individual questions. So please feel to come up and introduce yourselves and say what you didn't have a chance to say. And then at some point I will have to whisk them away to catch a train. So, but anyway, I want to give Professor Stipanowich a round of applause.
Thank you. Thanks so much.
Thank you.